So this week, the topic is voting in elections, and today's class session is going to be mainly for the purposes of talking about voting rights, okay, and particularly the history of extending voting rights. And then Thursday's class session, which will be recorded for you guys, is going to be more about, kind of the electoral arrangements that we have in existence currently in Texas, okay? So I'm going to begin by suggesting to you that when Texas became a state in the United States in 1845, this probably is not going to be shocking news to you guys, okay? It may not be news at all of any kind. You may already know this. When Texas became a state in the United States in 1845, only white males were eligible to vote. Now, that was a little bit of a change, believe it or not. It was a recent change, because if we go back to the founding of, well, certainly if we go back to the beginnings of the United States under the Constitution, the U.S. Constitution, which went into effect in 1789, it would have been property-owning white males, right? It wasn't just any white males were eligible. It was you had to own property, right? Those property qualifications for the right to vote, even for white males, began to come down in the early part of the 19th century. So that by the time we get to the 1820s, most states have dropped the property qualifications. But still, you had to be white male. Okay, so as I said, when Texas became a state in 1845, you had to be white male. That meant that women couldn't vote. That meant that African Americans couldn't vote. It meant that, for the most part, anyone other than a white male couldn't vote. Okay, so as I said, today's class session is going to be largely devoted to the history of how the right to vote was expanded to segments of society that were previously not allowed to vote. Okay, so let me throw out a couple of terms here that I'm going to be using in today's class session just to make sure that we're all on the same page. You all heard this term before? The franchise, what does that refer to? Anyone? It's just the term that is used to denote the right to vote. Okay? The franchise is the right to vote. So this term, what do you think this means? Enfranchise.
You can't vote.
No, it actually means the opposite, sort of. It means that given the right to vote or obtain the right to vote. Okay, so if a group of people are enfranchised, like women are enfranchised, that means that they now have the right to vote. Okay? And this term then would be what you're suggesting, which is to be denied the right to vote. Okay, so, those are terms that we're going to be using in today's class. I want to just throw them up there on the board so that you can see them. We can make sure that everybody has a good working understanding of what these terms mean before we get into the details of the history. Actually, I want to take this history lesson. This is not a history course, but I think sometimes it helps to have historical context, okay? So the history is not going to be in depth. My treatment is not going to go into a lot of depth. I just want to kind of outline some historical events that are very relevant to our discussion of the right to vote. And I want to take it in two different pieces. I want to first talk about two different groups in our society that have been historically denied the right to vote: women and African Americans. Okay, so I want to take the story of how women were enfranchised first. Okay, the story of how, whoops, I can't coordinate this and talk at the same time, so give me just a second here. The story of women's rights, the women's right to vote, women's rights more generally, actually goes back farther than a lot of Americans today really appreciate. I think if we were to take a survey and ask Americans, when was the women's rights movement in the United States, many people might say, oh, the 1960s, the 1970s. And there was a women's rights movement that got a lot of energy in the 1960s and the 1970s, but it actually really goes back to the 1830s, 1840s. Okay? And in 1848, a convention was held in Seneca Falls, New York. It's called the Seneca Falls Convention. Here you can see a billboard at the town limits of Seneca Falls, New York, where this convention was held. It says the birthplace of women's rights. And I think that is a fair claim that they can make because of this convention that was held there. It was organized by local Quaker women and attended by several notable individuals, including Elizabeth Cady Stanton. How many of you have heard the name Elizabeth Cady Stanton before? Show of hands. Nobody? A couple of, okay, few people. Frederick Douglass. Who's heard of Frederick Douglass? Okay. The great Quaker orator Lucretia Mott attended this convention. There are a number of individuals who were in attendance at this convention, and they discussed and deliberated the status of women and women's rights in American society way back in 1848. Okay. And they produced a document called the Declaration of Sentiments. Okay, here you can see a scanned copy of that document. And I encourage any of you who are interested in this area of American history, when you have some time, go out and do a Google search on the Declaration of Sentiments and read a transcription of that document. It's fascinating. I think some of you might be surprised by the language that's used in that document. It's modeled on the Declaration of Independence. Okay, it uses some very powerful language. Okay, whereas Jefferson in the Declaration of Independence is pointing his finger at George III and saying he's done this, he's done this, he's done that, he's done that. These attendees at this convention drafted this document where they're pointing their fingers at men and saying men have done this, they've done this, they've done this, they've done this, they've done all these things to deprive women of their rightful status in society and their full enjoyment of rights. Okay? So it's a very interesting document. Go out and read it. It won't take you very long to read. Okay? They also produced a series of resolutions, the most important of which was a call for Congress to introduce a formal amendment to the Constitution giving women the right to vote. So this is the first time that I'm aware of, anyway, I'm not a historian, but it's the first time I'm aware of that any sort of group of people, formally or informally organized, issued such a call to, suggest that the United States Congress begin the process to amend the Constitution for the purposes of giving women the right to vote. Over the next several years, a couple of decades, in fact, there was a series of these types of conventions all around the country, okay? Ohio, Kentucky, Illinois, various other places around the country, all of which reflected this growing energy for the women's rights movement. Now, most of the people who were active and involved in the women's rights movement were also very active and involved in the abolition of slavery movement. Many of them were, you saw the picture of Frederick Douglass that I put up there, right? Many of them were abolitionists. And as the Civil War approached, the leaders of the women's rights movement determined that the best strategy would be to put their agenda on the back burner in favor of uniting forces with all abolitionists to abolish the institution of slavery. So you don't have, after about 1858, you don't have too many of these conventions for a few years, okay? But after the Civil War is over and the Constitution is amended to abolish slavery and the 13th, 14th, and 15th Amendments are added to the Constitution dealing with the question of the slavery and the treatment of, people based on race, the efforts begin again, right? So by the time we get to the 1870s and the 1880s, you're starting to see a lot of these events again, okay? Elizabeth Cady Stanton and Susan B. Anthony formed an organization called the National Women's Suffrage Association. I'll just abbreviate it up here on the board. National Women's Suffrage Association. Formal organization, and its primary objective was to get Congress to actually propose that formal amendment to the Constitution. That was the stated objective of the organization. So again, in 1869, Elizabeth Cady Stanton and Susan B. Anthony formed this organization called the National Women's Suffrage Association. The primary goal was to win the right to vote for women through a formal amendment to the Constitution. On December 10th, 1869, Wyoming became the first place in the country to give women the right to vote, to enfranchise women. And there's a lot of speculation as to why that would have happened in Wyoming first. And there's probably multiple reasons for that, but one that I find particularly interesting that some historians seem convinced is a fair explanation is that they were trying to attract women to Wyoming. The population was overwhelmingly male, and they needed women to go to Wyoming. And so this was an enticement to get women to go to Wyoming. Why else would a woman want to go to Wyoming, huh? Wyoming's beautiful. Have you ever been to Wyoming? No? Oops. In 1890, that NWSA that I mentioned a moment ago, this keeps jumping around on its own. The National Women's Suffrage Association and another organization called the American Women's Suffrage Association. There were two during this period. But in 1890, they joined forces. They combined to form the National American Women's Suffrage Association. I think that's what it stands for. National American Women's Suffrage Association. But it was really more than just a name change. Okay? They decided on a new strategy. Okay? Rather than trying to get Congress to adopt an amendment to the Constitution, they decided on a state-by-state strategy to give women the right to vote. And they began to see progress in the last decade of the 19th century and the first decade of the 20th century. So you can see if you look at this map here, the states that are colored sort of whatever that, how would you describe that color? Orange? Scarlet, whatever that. Those states are the first states to give women the right to vote. You can see it's not a very good scan of this front page of this newspaper, but you can see that, you know, Wyoming in 1869, Colorado in 1893, Utah in 1896, Idaho in, I guess that's 1895. I can't really see that very well. Washington in 1910, California, Oregon, Arizona, Kansas, Western states mainly, right, that start giving women the right to vote. So it's definitely kind of a progressive Western movement, this strategy as it unfolds. In 1918, the state legislature in Texas passed a law that gave women the right to vote in primaries. Okay. Now let me digress here for just a second so that we can have a little bit better understanding of what this means. So even today, we talk about most elections having two phases, right? Whether we're talking about the election of national offices like president and Congress, or whether we're talking about state offices like governor and lieutenant governor and county offices and so on. They generally occur in two phases. The first is the primary. Okay? That's no surprise, right? So just it comes first, right? The second is the general election. Okay? So the general election is the one that determines who's going to be the next governor, okay? Officially. We have a governor's election among other elections here in Texas this year, right? I just use the governor's election because it's generally more visible than others, right? So the Republican candidate seems very likely to be the current governor, Greg Abbott. And it looks like the Democratic candidate is probably going to be Beto O'Rourke. Those two will probably, I could be wrong about that. I'm certainly not going to lay any money on it, either one of those two guys. But let's just say it's Beto and Governor Abbott that are in the general election. So they'll square off in November, and the winner of that race will become the next governor. Okay? But how did the Republicans get down to Greg Abbott? And how did the Democrats get down to Beto O'Rourke? And that's the purpose of the primary, right? The primary is a process that's used by the parties to nominate their candidates. So you start, in many of these instances, you start with a field of candidates. Like you might start with, you know, in Texas, for example, in governor's elections, you might start with as many as, you know, 4 or 5, 6 Republican candidates, or 4 or 5 or 6 Democratic candidates. How do the Democrats get down to one candidate? How do the Republicans get down to one candidate? That's the function of the primaries. Okay, so the bottom line is, it's not, people call them primary elections, but they're not really elections. They're a nomination process. Everybody, that's a very important point for us as we move along with this discussion on this topic. Okay, so I'm digressing here for a moment just to clarify that. Okay, to get back on track with this point about the history, is that in 1918, the legislature over in Austin passes a law that says, okay, we're going to let women vote in this phase, but we're not going to let women vote in this phase. Which is an interesting thing, because it kind of works the opposite way when we start talking about race, which we'll get to here in just a second. Anyway, it wasn't a decision that had an impact for very long, because the following year, in 1919, the United States Congress formally proposed the amendment to the Constitution to give women the right to vote. And in 1920, Texas became the first state in the South, block down here, Texas became the first state in the South to ratify that amendment to the Constitution. All right. So with that, I said it was going to be a brief history, just hit some highlights. That's, I think, pretty much the important events that we need to be aware of to kind of understand how this process of enfranchising women came to be. As I said, if you're interested in this part of our history, if you're interested particularly in gender equality or women's rights, then you may want to do some investigation on your own. Okay? There are other things certainly that are worthy of your attention, but in the limit of time that we have, I really just wanted to hit on these few things. Okay, so any questions about these points? All right. So let's turn our attention then to the story as it pertains to enfranchising African Americans. And I think here we want to begin with the end of the Civil War. Okay? So when the Civil War came to an end in 1865, you had 3 new amendments that were added to the U.S. Constitution, the 13th, 14th, and 15th Amendments. Okay? The 13th Amendment in 1865 prohibited slavery in the United States. The 14th Amendment in 1868 does a number of things. Okay? There's several provisions of the 14th Amendment that are very important, but in terms of what we're talking about here today, there's something called the Equal Protection Clause in the 14th Amendment. That clause says that no state shall deprive any person within its jurisdiction of the equal protection of the laws. Okay? And that's a pretty short little phrase, easy enough for me to commit to memory. Okay? But it has far-reaching implications. And then the 15th Amendment, which came in 1870, denied the states the right to vote on the basis of race, creed, color, previous condition of servitude. So you have this amendment added to the Constitution in 1870 that says that the states can't deprive individuals the right to vote on the basis of race. Now, you probably know enough about American history to understand or appreciate that just because these words were added to the Constitution didn't mean that somehow magically people were given the right to vote or allowed to vote without respect to race. You're probably aware that we have a history for some decades to follow where African Americans in particular struggled to achieve full voting rights. And that's the story that we're going to talk about now. That despite the 15th Amendment, you have an ongoing struggle to enfranchise African Americans. Okay? One of the things that happened after the Civil War, we alluded to this in the previous class session, although in a very different context. We said that in Texas, as well as other former Confederate states, former Confederates were disenfranchised. Didn't that come up in a class session here? I think we talked about that in connection with the Texas Constitution, if I remember correctly. So we're talking about mainly white conservative Democrats in the South, in Texas, and in the South more generally, who were disenfranchised. What does that mean again? I erased it, but mentioned it, put it up on the board earlier. What does it mean to be disenfranchised? Having the right to vote taken away from you. Okay, now why would former Confederates have been disenfranchised? Well, the simple answer is punishment for treason against the United States in the Civil War. You know, Abraham Lincoln, before he died, before he was assassinated, he very strongly tried to encourage his fellow Republicans not to exact vengeance, right? To just, it's time for the nation to heal, etc. Of course, Lincoln's position didn't prevail. He didn't want punitive measures imposed on the former Confederates, if I understand that part of the history correctly. But, Lincoln was assassinated, and other elements of the Republican Party that was in control at the national level after the Civil War did impose punitive measures. And part of the punishment was to have the right to vote taken away. Okay? Also the right to hold public office. And that meant for a fairly brief period of time, in places like Texas and elsewhere in the South, African Americans enjoyed the right to vote and hold public office. I think I told you, for example, in that discussion on the Texas Constitution, that 1869 Texas Constitution was written mainly by Republicans at a convention where it included 10 former slaves that were in attendance as delegates to that convention. Okay? So for a brief period of time, you have, as a result of military rule being imposed in Texas and in the South more generally, Republican-controlled government, Republican Party controlling the government, you have the enfranchisement of African Americans and the ability of African Americans to hold office. But it was short-lived, okay? Because Reconstruction comes to an end by 1875, and the former conservative white Democrats in places like Texas, elsewhere in the South, came back to power. Okay? And so when they came back to power, when they regained their right to vote, when they regained their right to hold office, the old power guard just reemerged. And the repression, whatever progress had been made during the Reconstruction era with respect to racial equality and civil rights, in particular voting rights for African Americans, pretty much just melted away. And even though you still had the 15th Amendment in the Constitution, the states undertook all kinds of efforts, particularly the southern states, undertook all kinds of efforts to prevent African Americans from voting. So that by the time we get to the turn of the 20th century, by the time we get to the year 1900, there are fully 650,000 African Americans living in Texas who would have been eligible to vote during the Reconstruction period, but because of a variety of devices that Texas was using in the subsequent years after Reconstruction, were not eligible to vote. 650,000. So I just want to tick off a couple of the impediments that were used in places like Texas and other southern states to prevent African Americans from voting. Let me take this off for just a minute. I don't have anything to show you on the screen. So I want to begin with something called the white primary. Any of you heard of that before? The white primary, which was in practice in Texas and elsewhere in the South. I'm going to stop saying elsewhere in the South. Just understand that the general Southern kind of thing, right? This was the practice of the Democratic Party prohibiting African Americans from participating. What is the purpose of the primary? We just said a few minutes ago when we distinguished between primaries and general elections. What's the purpose of a primary? To nominate the party's candidates. Okay, now during this period, Texas was a one-party state. It was anathema to be Republican in Texas, in the South. I've told you in a previous class meeting, for example, that from 1875 to 1976, no Republican served as governor of the state of Texas. 100 years. All Democrats. If you were a Republican in Texas, your chances of being elected governor or most other offices, certainly at the statewide level, were, as our friends in the mathematics area would say, asymptotically approaching zero. It just is not going to happen. Did not happen during this period. So what I'm trying to tell you is that all of the action was in the Democratic Party. And whoever won the Democratic Party's primary then became the next governor, de facto, of the general election. The general election still occurred, right? But the decision, ultimately the determination of who the next governor or lieutenant governor or whatever the office is going to be made in the Democratic Party primary. So if the Democratic Party primary is not allowing African Americans to participate, then that in effect means that African Americans have no say in who their next governor is, or who their next state representative is, etc. So that was the practice up until 1923. In 1923, the Texas legislature over in Austin actually passed a law codifying that practice, what had just been a practice. The Texas legislature says, oh, we're just going to write that into the laws of the state, that African Americans are not permitted to participate in the Democratic Party primary. Remember, those lawmakers would have all been Democrats. And they would have been white Democrats. However, in 1924, 1923, the state passes the law. Right? In 1924, a case goes before the United States Supreme Court called Grovey versus Townsend. And in that, oh, excuse me, I gave you the wrong citation. Jumping ahead of myself a little bit. Change that. Nixon versus Herndon. And in that decision, the court ruled that the law of the state of Texas violated the 15th Amendment of the Constitution. What does the 15th Amendment of the Constitution do? prohibits the states from depriving the right to vote on the basis of race. So the court is saying, Texas, you can't have that law. It violates the Constitution. But the Democratic Party of Texas, subsequent to that decision of the United States Supreme Court, just adopted a rule. There's a difference here between the state of Texas, the legislature over in Austin, passing a law versus the Democratic Party of Texas passing an internal rule, making an internal rule that just says, well, we'll just go back to the way it was before 1923, which was we just don't let blacks in. We just don't let blacks participate. And that question went before the Supreme Court in that case that I was trying to get to too quickly, Groby versus Townsend. So the question before the Supreme Court in 1934 is, can the Democratic Party of Texas have a rule prohibiting African Americans from participating? Anybody want to guess what the court's answer to that question is? Yes or no? It's a coin flip. Right, just flip one, right? What does the Supreme Court say? Anybody be bold? No. No, they actually say yes. Wait a minute, what was the question? I forgot how I framed the question. The question before the court is, can the Democratic Party of Texas prohibit African Americans from voting? And the court's answer to that question is yes, they can. Why? Well, because they said that the Democratic Party is a private organization. It's not the state of Texas. It's a private organization. And as a private organization, it can allow people who it wants to be in its primary to be in it. It can allow people that it don't want to be in its primary to not to be in it. You see, the 15th Amendment doesn't prohibit private organizations from denying access. It prevents the state. Everybody with me? But in 1944, in the landmark case, Smith versus Allwright, the court disposes even of that argument. In Smith versus Allwright, the white primary finally comes to an end. Because what the court says in 1944, unlike its predecessor court 10 years earlier, is that, well, the Democratic Party may not be the state of Texas, but it's acting as an agent of the state of Texas. It is essentially running the election for the state of Texas. And so therefore, as an agent of the state of Texas, it is also prohibited by the 15th Amendment from denying the right to vote on the basis of race. Got questions about that? Okay, so bottom line, by 1944, or as a result of the court's decision in 1944, the white primary is a thing of the past, no longer used. Even Texas couldn't get around that. All right, the second device, I guess we can say, that Texas and other states used to effectively prevent African Americans from voting was the poll tax. Okay. Some of you may have heard of the poll tax before. Okay. The poll tax is, its simplest way we can describe it is it's a fee that people had to pay in order to register to vote. And here you can see a scan of a receipt paid by a Mr. H.R. Rogers, Jr. in January of 1964 in the sum of $1.50 to Harris County, Texas, to satisfy the obligation of the poll tax. And I think many people today would look at that and say, $1.50, that's nothing. right? That's no barrier to anybody voting if they really want to vote. But you have to understand $1.50 in 1964 was worth a lot more money than it is in 2022. Sometimes when I have time, which is not, I'd be real honest with you, it's not very often, but sometimes when I have a little time on my hands, I'll be scanning through the television. Do any of you watch TV? Nobody watches TV anymore. I've had conversations with students in recent years where they swear they don't watch TV. And I finally figured out that what they meant by that is they don't watch this device called a TV, but they watch TV programming. I remember walking through a hallway in this building a couple of years ago, and there was a group of people sitting around at those tables over there watching an episode of Friends. We're not watching TV. Okay, all right, not watching TV. Well, anyway, I still watch the old TV set sometimes, very rarely. And usually if I do, it's on something like BBC or PBS or something like that. But occasionally I'll be scanning through, and I'll come across one of these old TV shows from the 1960s, like say the Andy Griffith Show or something like that, where, the dad will be giving his son a nickel, and like the kid is so happy because they've got a nickel, right? It's so much money, right? Well, that in 2020, I think, which was 2021, when I did this adjustment, that $1.50 in 1964 was about $13.24 today. So let me ask you this. Do you think $13.24 today would deter anyone from registering to vote? That still may not. You guys may be children of privilege. I don't know. But $13.24 may not seem like any kind of money at all to you. But do you think there are people that might be real money to? If you are, for example, trying to buy your infant formula, you're having trouble getting from one paycheck to the next, and clothes for your growing children or something like that, or keeping the heat on in your apartment or your home, wherever you live, $13.24 might be a big deal. So $1.50 back in 1964 might have been a big deal for some people. And most historians agree that the real intent of the poll tax in Texas and in Virginia and other states where this was used was really to prevent African Americans from voting. Because even though everyone had to pay the poll tax. The fact of the matter is, during this period of our history, African Americans were disproportionately poor. And so it would have also caught up poor whites, and poor Latinos probably would have not been able to pay the poll tax, but it was disproportionately African Americans. And as I started to say, most historians agree that the real purpose of the poll tax was to prevent African Americans from voting. In 1964, the same year that this is dated, okay, the United States Congress proposes an amendment to the Constitution ratified later in 1964, the 24th Amendment. And that amendment prohibited states from imposing a poll tax in federal elections. So the Constitution is amended in 1964. The 24th Amendment is added. That amendment prohibits states from imposing a poll tax in federal elections. By federal election, we mean elections for the president, elections for Congress. However, Texas, Virginia, and other southern states essentially said, well, we may not be able to impose a poll tax in presidential elections and congressional elections anymore, but we're going to keep on imposing the poll tax when it comes to state and county and local elections. They created what came to be called the dual ballot system. Okay, so in Texas, They rewrote the law so that even though you could no longer impose a poll tax to vote in presidential and congressional elections, the poll tax was still going to be imposed in state and local elections. In 1966, 2 years later, the United States Supreme Court hears two cases, one coming out of the state of Texas and the other coming out of the state of Virginia. I'm just going to abbreviate here. Harper versus the Virginia Board of Electors. In both of those cases, the Virginia system and the Texas system was very similar, the dual ballot system. And in both of those cases, the Supreme Court said that the dual ballot system violates the 14th Amendment Equal Protection Clause. In a sense, what the Supreme Court was saying in its decision is that Texas, Virginia, you're not fooling anybody. We know what you're doing. You're trying to keep African Americans from voting in any way you possibly can. And this is a violation of the 14th Amendment. Notice I didn't say the 15th Amendment. I said the 14th Amendment. The 14th Amendment Equal Protection Clause. That's the one I mentioned earlier that says no state shall deprive any person within its jurisdiction the equal protection of the laws. And the court says that this is an invidious discrimination and that the motivation is to prevent African Americans from voting. And so therefore, it's a violation of the 14th Amendment. Okay, questions about that? So with that, the poll tax comes to an end. 1944, the white primary comes to an end. By the mid-1960s, the poll tax comes to an end. There were other devices that were used. As I said, we don't have time to go into all of them, but things like grandfather clauses. Have any of you ever heard of those before? What's a grandfather clause? Anybody know what that refers to as it pertains here? The term grandfather clause might be used in a variety of applications, but as it pertains to the right to vote, have any of you ever heard of that before? This would have affected African Americans in the generation or two after Reconstruction, because essentially what it said is if your grandfather had the right to vote, Texas had these kinds of laws. If your grandfather had the right to vote, then you have the right to vote. Well, because for so many African Americans in those years, their grandfathers were slaves and they didn't have the right to vote, that would have meant that even if they were otherwise qualified to vote, they wouldn't be able to because their grandfather wasn't able to vote. Literacy tests at a time when African Americans were disproportionately undereducated and so many didn't have the ability to read and write, they would have been prohibited just on that basis because they couldn't read or write. In some jurisdictions in Texas, they required frequent re-registration so that made it very difficult for many African Americans and Latinos, by the way, particularly people who were like migrant workers, didn't have permanent addresses. During the early part, up to the middle part of the 20th century, there were many African Americans in Texas that lived in residences that did not have street addresses. So if you didn't have a street address, they would deny you registration to vote because, after all, they would say, how do we know what precinct to put you in? You don't have a street address. So all of these things, others, really were part of an overall effort to keep barriers up, okay? In 1965, you can tell the 1960s were a vital era, right? In 1965, the United States Congress passed legislation called the Voting Rights Act, which was amended at various intervals in the years to follow. But the original legislation in 1965 had a couple of very important pieces. What Congress said in 1965 is that all of these practices that are used by states as barriers to keep African Americans away from the polls or anybody away from the polls on the basis of race are a violation of federal law. So presumably, state officials that implemented these barriers could be prosecuted under the Voting Rights Act. But to be honest with you, that really wasn't the more important of the two pieces. I don't want to minimize the importance of that, but really the more important piece was this: the pre-clearance provision. You read the chapter in the textbook today in anticipation of the quiz. The authors of your textbook comment on this pre-clearance provision? Maybe they don't call it the pre-clearance provision. What this part of the law says is that if a state that has had a history, either history or contemporaneous pattern of discrimination on the basis of race, and that would have included Texas and Mississippi and Alabama and Tennessee and Arkansas and Georgia and Virginia and West Virginia, right? Mainly the southern states, right? If they had a history in the past or contemporaneously, currently, in 1965, any sort of pattern of discrimination on the basis of race, that if they try to change state election laws, it has to be pre-cleared by the U.S. Department of Justice, which of course is headed by the Attorney General of the United States. Now remember that in the United States, from the very beginning, under the Constitution, down to today, this is true today as well, states run elections. States write the election laws. In fact, you just took the quiz and there was at least one question on the quiz to that effect. We don't really have national elections in the United States. Even elections for the president are really not national elections. It's an election that's occurring in 50 different states simultaneously. And that's what the election laws differ from Texas to Georgia to Pennsylvania. That's why in the 2020 election, in the aftermath of the 2020 election, Donald Trump, who was challenging so hard, was challenging at the state level. Right? He was trying to get certain states to reconsider the outcome. Well, how could the outcome be any different? Well, because state laws differ. So it is true under the U.S. Constitution, from the very beginning till now, states write the election laws. So if a state is going to propose to adopt a new law affecting voting or elections, if it's one of these states, like Texas, that had a history of discrimination on the basis of race, it's going to have to be cleared first. The U.S. Department of Justice is going to have to issue a finding that it's not discriminatory. So, for example, in 2011, a decade or so ago, the legislature over in Austin proposed a law that would require voters to show one of only 2 or 3 forms of photo identification in order to be able to vote in Texas. A driver's license or a concealed handgun license. But not, by the way, a university ID or employment ID. Okay? There were only like 3 or 4 forms of identification that were allowed under Texas law. But because of this provision of the Voting Rights Act, the U.S. Department of Justice had to enter a finding before it could be adopted and go into effect, had to enter a finding that it was non-discriminatory. But the U.S. Department of Justice would not do that with respect to the Texas law. Okay? And then in 2013, in a case called Shelby County versus Holder, that's Shelby County, Alabama, I think. There is a Shelby County in Texas, but this case came out of Alabama. Holder was the Attorney General of the United States during the Obama administration, the head of the Department of Justice. This case goes before the United States Supreme Court involving a local county ordinance in Shelby County, Alabama, challenging the Justice Department's authority under this preclearance provision. And the Supreme Court says in its decision in this case that this provision is void. In other words, what was the enforcement mechanism of the Voting Rights Act? The Supreme Court guts it. Look, think about this for a second. What is Congress saying in 1965 when it passes this Voting Rights Act and providing this? It's essentially saying this. Up until that time, if a person believed that they had been discriminated against in this area of voting, for example, but in other areas, if they believed that they had been discriminated against on the basis of race, what was their remedy? To go to court with all that entails, getting lawyers and all that sort of stuff, and the time that, appeals process and everything that gets all dragged out. That was really your only remedy. If you felt like you had this grievance that you were discriminated against on the basis of your race. What Congress is saying in 1965 is we shouldn't have to wait for the courts. And the slowness of the court. The courts are justifiably slow. Okay, it just takes time. But we shouldn't have to wait for that. We should be able to remedy this proactively by preventing the states from enacting discriminatory laws in the first place. And so that worked. That strategy worked for a number of decades, from 1965 up until 2013. And maybe that's why in recent years, people, in the last couple of years, the whole question of voting and access to voting has been so much in the news because states have done what? States like Texas have done what? Georgia, Texas, Arizona, other states have done what? They've enacted new voting laws that are no longer subject to the pre-clearance provision. And many people argue that they are really efforts to do what? To restrict access to voting. I mean, obviously the supporters of those laws have other justifications. They're not going to say, if you ask Republican majorities in Texas legislature or Georgia legislature, hey, why did you adopt this law? They're not going to say it's to restrict access to voting. They're not going to say that. They may not even believe that. For example, people who support photo ID laws, they don't say, well, we're trying to restrict access to voting. They say we're trying to make sure that people who are voting are actually eligible to vote. You're trying to prevent fraud. That's what they're going to say. But, at some point, someone has to get down to the nitty-gritty. And regardless of what they say, what is the principal effect? And if Congress is saying here in 1965 that the principal effect is, all those laws that we talked about in this history, no state was ever going to say, well, we're trying to keep African Americans from voting. Nobody's going to say, defend the poll tax and say, well, really, what we're really trying to do is keep African Americans from voting. Nobody's ever going to say that, right? So ultimately, some arbiter has to decide, well, what's the principal effect, regardless of what they say the purpose is. And in the case of the poll tax and some of these other devices, they concluded, well, that the effect was to prevent African Americans from voting. So it was discriminatory. So do you understand what I'm saying? Like this whole debate over photo ID laws, which some people think there are very good arguments on either side, at some point, you got to get past what the supporters say and what the opponents say and look at the effects. So we'll see how that plays out. I think photo ID laws are here to stay. Because after this decision in 2013, Texas did adopt a photo ID law that no longer had to be, that is the law in Texas, right? Did any of you vote? Have any of you voted ever? Right? You have to present a photo ID? Of course you did, because that's the law in Texas, right? But it's not the same version of the law that Texas adopted immediately after the court decision. Because there have been court cases, not Supreme Court decisions, but lower federal court rulings, which have essentially said, raising the question about Texas law, photo ID law, Texas, the main finding is that, well, Texas can have the photo ID law, but they're going to have to be a little bit more flexible on the forms of ID. Because there are some forms of ID that certain people just can't get, are not likely to get. It's not practical for them to get. It's hard for them to get. Like maybe people who live out in rural Texas where the closest DPS office is 250 miles away. So you don't drive, so you don't have a driver's license. You can't get the state issued ID because you can't get to the DPS office 250 miles away because you can't drive. And why, by the way, some people ask, do we allow, under Texas law, a concealed gun permit? Aren't certain people more likely to have that than others? Why we can allow that, but we don't allow student IDs or some other form of ID? It's all questions, good questions that are raised. But ultimately what the courts have said is, Texas, you've got to be a little bit more flexible. And so they'll allow things like if you can't present the forms of photo ID specified in the law, you may be able to present some other forms of ID that at least provisionally verify your identity, like, say, 2 utility bills with the same address on them, something like that. All right, questions about that? Any questions about these historical facts that I've thrown at you today? A lot of court cases and dates of laws and so on. But as I said, I think it's important to understand the historical context. I mean, really, how can we possibly understand what's underlying that debate over a current issue, like, say, a photo ID law, if we don't understand the historical context? All right, well, we don't have enough time really remaining in today's class session, unfortunately, to get to the next piece, which requires a little bit more time to elaborate. So I think I'm just going to leave that till Thursday. We'll dismiss a little bit early today. I'm sure you're disappointed. We'll dismiss a little bit early today, and we'll just, on the Thursday class session, which will be recorded for you, we'll just pick up with Ernest to get to those next few items. All right, we'll see you next week.